leave it to my opposing counsel to provide the biblical detail, as he did in his brief of the enrolled bill doctrine. But in brief, the enrolled bill doctrine stands for the proposition that the provision in Article 4, Paragraph 8 of the Illinois Constitution that says once the President of the Senate and the Speaker of the House have signed off on the fact that all procedural requirements have been met in order for a bill to pass to the governor's desk, um, that precludes any investigation into whether, in fact, all of those procedural requirements have indeed been met. So I'll start there, Your Honor, which is not exactly where I wanted to start, but here we are. And I must also start, since you asked the question right out of the gate, um, about the enrolled bill doctrine. We are here to ask for a good faith decision that would change the law with respect to the enrolled bill doctrine. As we have noted in our briefs, the Illinois Supreme Court been has decided that the enrolled bill doctrine does preclude judicial review of complaints of the nature that my clients make, the three readings rule. We believe, though, the Supreme Court has gone too far. We do not think that a blanket preclusion of review is appropriate under the plain language of the Constitution, the meaning of all of these provisions, and even the Supreme Court decisions themselves. And so the seminal issue before you is whether the enrolled bill doctrine does preclude, as a matter of law, judicial review of a complaint that originates under the three readings rule. And the three readings rule is also quite simple, and that states that a piece of legislation must be read by title 3 times in each chamber. That constitutional requirement is contained in Article 4, Paragraph 8 as well. But the ruling that the enrolled bill doctrine precludes review implicates a few important principles. The first of which is what is the purpose of a three readings requirement at all? As we have argued, applying the enrolled bill doctrine in the manner in which it has been applied renders the three readings requirement meaningless. If it is truly not required, if the legislative leaders say so. But as the Illinois Supreme Court has said, as the U.S. Supreme Court has said, the purpose of a three readings requirement, and they are in likely every constitution in the United States, is to ensure that the legislature knows what it is passing, what it's voting on, and in addition, so that the public knows what is moving through the legislative process. Then and only then does the public have the ability to petition their the legislators intelligently about a piece of litigation. If you don't know that it's moving through the process, you're deprived of this ability. And that's exactly what happened here. In this case, and it's unfortunately not an unfamiliar refrain, a piece of very innocuous legislation dealing with Section 2-616 of the Civil Procedure Code moved through the legislative process. It was indeed read by title the requisite number of times, but in a matter of hours before the end of the legislative session, approximately 30 hours or so, the bill was completely gutted and replaced. So yes, it's an amendment.
Also, doesn't the Constitution only require that it be read by title?
That's right, Your Honor. That's right. And I will, as we have also argued, simply naming a bill a an act with regard to civil law, for instance, does not meet the does not meet that constitutional requirement. We contend that such a vague title does not accomplish the purpose of that provision. When the public or the legislature is unable to determine, an act with regard to civil law could be a myriad of things. And we assert that to really properly adhere to a three readings requirement that does apprise the public and the legislature of what is within a bill, that a bill's title must be sufficiently descriptive to differentiate what it is. And if that bill's
How
title
does
yes, I'm sorry, Your Honor.
the titling of legislation somehow fall within this branch's jurisdiction?
Well, you, uh, not squarely, Your Honor, but it does bring up really the second principle that this case impinges upon, and that's the principle of separation of powers. Um, where is the line between the judiciary, ensuring that constitutional provisions are followed, and the power of a separate branch? Where is that line? That's
Well,
that's
taking your argument as you just made it, you're proposing that if members of the legislature decided that they felt legislation passing through the process was not sufficiently titled, they could sue and then require a court to determine whether the title of that legislation, which isn't even an act yet, is sufficiently illustrative of the purposes. That really doesn't sound like something that judges should be doing. That sounds like something that you guys are supposed to, that's the sausage making that you guys engage in.
Well, it is sausage making, and I'll concede that does get messy. Um, but what we're operating with now is really an extreme process. And so, yes, would properly titling a bill when its purpose completely changes take a little bit more time? Um, yes, it would. But that's not a bad thing. The purpose of a readings requirement at all is to encourage deliberation. It is to ensure that what happened in this very case doesn't happen. A significant piece of legislation rolled through the General Assembly in 30 hours, greatly expanding the jurisdiction of Illinois courts over toxic tort litigation. No serious debate, no chance for the public to weigh in or not. And so, yes, I would concede that having the judiciary policing the titling of bills, it is not ideal. However, at the end of the day, our contention is that yes, it is the province of the judiciary to ensure that the Constitution is followed. And on the other side of this is the defendant's suggestion, and it's not without merit, but that they will be the ones who will ensure that this constitutional provision is followed by them. And we think that's untenable. We think that this is an appropriate place for the judiciary to step in hesitantly, but that's what the Supreme Court has said, that, you know what, they are hesitant to allow the legislature to continue to police itself because of separation of powers issues. But it's something that they would look at again. So that is our contention on that point, Your Honor. And so in brief, so the way that we sort of differentiate this case from the others that have come before you in I just don't know if this argument has been made before, but reading a bill by title, if you look at the definition of what a title is, it has to differentiate itself. And we think that's important in this case. We think the words should be construed as they are written and understood. And we think that is a good place to is a good place to start. We rely on Justice Heupel's dissent, and it's a dissent. We acknowledge. Other justices who have like Justice Overstreet, others who have looked at this issue before and have raised the red flag as to this continued practice. We have sought to put what might be a possible solution to ensuring that this constitutional provision is indeed followed, and not to allow the enrolled bill doctrine to completely bar judicial review, but to look at it with a new lens. So thank you very much for your time.
Thank you, counsel. Mr. Vaught?
Good afternoon. May it please the court. I'm Adam Vaught on behalf of Speaker Welch and President Harmon. The Circuit Court dismissed this lawsuit on two independent grounds. Either should be affirmed, because of the enrolled bill doctrine of Article 4, Section 8 forecloses a 3 readings challenge, and second, that the plaintiffs lack standing under Flynn versus Ryan. I'll be brief on both, and I do just want to note, I understand the purpose of this lawsuit is to try and persuade the Supreme Court to reverse its precedent. And to do that, Mr. Fogarty has to get to the Supreme Court, which means it has to come through this court first. And so, he is faced with the Supreme Court's precedent, and I respect his advocacy. But at this court, the prior precedent still control, as the court recently stated in First Midwest Bank versus Rossi. But as Justice Connect wanted to start with the biblical description of the enrolled bill doctrine, I can go as far back as 1818 under our first Constitution, which in the beginning it had a 3 readings requirement, but mostly relevant to what we're discussing here is the 1870 Constitution, in which the 3 readings requirements said that the bill needed to be read in full on 3 separate days. Now, in full meant it was supposed to be read in its entirety. And the purpose of that was both a notice provision, because printing was much more expensive in 1870 than 1970. And second, there were illiterate members of the General Assembly. I mean, it was 1870. Public education wasn't, what it is today, or 1970. But by 1970, society had changed. Literacy was, down significantly, especially among people who would be elected to the General Assembly. Printing costs were much lower. And so the 1970 Constitution decided to change the three readings rule. But not only that, they changed what was called the journal entry rule, which meant that if you wanted to challenge whether or not the procedures were followed, you had to look to the House and Senate journals. The Constitutional Convention instead decided to use the enrolled bill doctrine, which meant that if the president and speaker certified that the procedural requirements were met, that then the courts wouldn't look at it. That was the end stop. And the point of it was both to minimize lawsuits, because there had been lawsuits that had reached even the Supreme Court on this issue. And in fact, the General Assembly had struggled with the full reading. They'd usually waived it, or just everybody agreed that they weren't going to read it, because having somebody, a clerk who has to sit there and read every bill 3 times in the General Assembly, was just daunting. So that's why the convention decided to get rid of it. And the Supreme Court has recognized that in every case to reach it, starting in Furmeyer in 74, Benjamin in 77, Pollock in 1980, which has very similar sort of, facts to this, as there was an amendment that changed the legislation. There was Gejas and Cafe in 1992. That was, of course, when Justice Heupel wrote the majority opinion, but he said that the framers had, envisioned that the enrolled bill doctrine would apply. That is where the famous language that the court may revoke the deference to the legislature on this. But since then, in Contillo in 94, Dunnigan in 95, the majority held it, even though Justice Heupel was then in the dissent. Friends of the Park in 03, they did repeat similar language, but at that time they scaled back from saying they may revoke their deference to saying they urged the legislature. And then even recently in 2005 with Piazza Armory, Justice Overstreet dissented on it, but the majority did not reach the issue. Based on that, this court in First Midwest versus Rossi found that there was nothing it can do to change it, even though this court suggested it did not think the legislature was following the practice. Accuracy firearms, the 5th District did the same, and Doe versus Lift, and the 1st District also held the same. I must kind of want to talk a little bit about, the general issue here, which is transparency. And, the 3 readings requirement exists to give members and the public notice of pending legislation, but it's not really meant to inform you of exactly what's in the bill. Because if you read if you read Section 8D, the very next sentence says that every bill has to be read by title in 3 days. It then says that
Okay, let's stop there. That is a good historical perspective, and I understand progress, and I understand why it is impractical to read the whole bill, and so things have changed. But Mr. Fogarty makes a point. Why not have the title actually describe what the bill is? That at least gives some notice, which is absent in this instance. That gives some notice to the rest of the legislature, to the public, of what's going on.
Well, let me start with what the Constitution requires and then talk more like the policy of it, because I think they're a little bit separate. So the Constitution just says that it has to be read by title. It doesn't state what a title is, how the script of a title has to be. And the Supreme Court and single subject legislation cases have, stated that broad general titles are fine. The only title that has to be given is appropriations have to have a title of appropriations. Now, to the policy of why not make it more, specific, I suppose then the question becomes, it's just a matter of legislative drafting. Every time there's an amendment to something, do you have to then change the title? But, again, even in single subject legislation, the title doesn't even govern whether or not it's a single subject. Courts can look at the totality of the legislation and craft on a subject that is different even from what the title is, maybe broader or more narrow, as long as the court can say, as a matter of policy, this is one general single subject, then it passes. So the fact that the title isn't necessarily specific, certainly not a constitutional problem, but even from just a legislative management, it as we noted, LRB's manual, I know council said that we're trying to elevate LRB's manual to constitutional principles. It's not that, but it shows that there is a process on how these bills get drafted. I mean, there's an independent body that does that works with legislators, lobbyists, and staff to try and, prepare these bills. And, they have a process to try and manage it so that, bills can track through without, getting bogged down in all sorts of procedural messes. And so that would be my answer why not require a more specific title beyond the fact that the Constitution itself does not require that. But I would say too that, that there is also the second part, where is that every bill and amendment has to be on the desk of the legislature when they're voting on it. I mean, it used to be there was a printing office that would print off all these bills, and you'd see members' desks with stacks and stacks of paper. Now it's on the website, and in fact, everything that the General Assembly does is now available on the General Assembly's website in real time. The world can see amendments and bills filed at the same time that members do. They can watch the proceedings online, wherever they are in the world, as long as they have internet access. Between social media and email and texting, I mean, you can get out information quickly. And this particular bill, I remember I had no involvement with it, but I remember it came out. I believe there were some news stories on it. I mean, it did generate interest. So to say it, came out of nowhere and nobody knew about it and it passed, I just don't think is fair. The issue isn't that nobody knew what was in the bill. I think, in fairness, Mr. Fogarty's clients just don't like the bill. They were aware of what it did. It doesn't take long to read it. So, I mean, everybody who wants to know about what is happening in the General Assembly can do so, regardless whether or not, having specific titles or not. I mean, the access to the information is what the real concern is. And that's been, that actually is something that they couldn't even envision in 1970, what we have access to today.
Would you concede that absent the enrolled bill doctrine, more would have had to been done here?
I don't, Your Honor, I don't. And here's why, because it says that the bill has to be read by title. And so the title is an act regarding civil law. This originated as a bill that did something to Section 2-606, and then ultimately changed it to require jurisdiction for toxic torts if you're doing business in Illinois. The title never changed, and it was read 3 times. So in each house, and that's conceded, I believe, both in the briefs and certainly it's on the journal that you can view on the General Assembly's website. So under the Constitution, it doesn't give a specificity requirement into the title. It doesn't state how much detail there has to be. So I don't know how you craft a constitutional line that would say this bill wasn't sufficient because it was too general, that this bill was okay. Again, it's sort of, the question of a separation of powers. The judiciary should just leave that to the General Assembly for them to decide. I mean, the General Assembly itself has ways of dealing with this. They craft their own rules in the House and Senate. And, we cited in our brief the various ways individual members could challenge a 3 readings issue or challenge the title. They can certainly amend the title. And then, to get into the parade of horribles that the Speaker and the President start certifying, legislation that was never introduced, never voted on. The members can remove the Speaker and the President. Voters can vote them out. I mean, there are procedural safeguards beyond just, what Mr. Fogarty says is trust us. I mean, there are many places in our constitutional structure that we do, in fact, say trust us. I mean, everybody from the president to, the village clerk has to swear an oath to the Constitution. We don't judicially, review whether or not they meant that or not. The Constitution requires the presiding officers to certify that these procedural requirements have been met, and it should be presumed that they're operating and certifying and with honesty that they have been met. If I can then just, I want to briefly just happy to answer any questions, of course, but just talk about standing. Here we have members of the General Assembly who are arguing that a bill which requires corporations to submit to the jurisdiction of the state of Illinois if they're doing business for toxic tort litigation, that they have standing to present this argument. They don't. I mean, standing requires it has to have an interest that would affect, and something has to affect you or is in immediacy of affecting you. Here, they're not corporations. This could never apply to them. Flynn versus Ryan was a case that's, I think, directly on point, where a state senator sued on the gift ban and the Supreme Court said he didn't have standing because it hadn't been applied. at least with the gift ban, it could have applied to him at some point. Here, this could never apply, so the court could affirm on that as well. You know, to close, I would say that, the enrolled bill doctrine was a choice that was made at the Constitutional Convention. Within that, when the voters ratified the Constitution, that was brought in. The Supreme Court has recognized that for 50 years. I respect that Mr. Fogarty's clients want to ask the Supreme Court to revisit it. But for this court, those precedents are still binding, and so we would respectfully request that the
I see no questions. Thank you. Mr. Fogarty, rebuttal.
Yes, thank you, and I'll be very brief, and thank you. With respect to the, oh gosh, I'm sorry, I just lost my train of thought here. With respect to the idea that the legislature should be the ones who enforce, in essence, or ensure that this the 3 readings requirement is indeed met. We would respectfully ask that you consider that it is indeed the province of the judiciary to ensure that a constitutional provision is being met. We would also ask that with regard to the enrolled bill doctrine, that the view that the certification of the President of the Senate and the Speaker of the House would create a rebuttable presumption. That's prima facie evidence where someone who found themselves to be aggrieved could possibly rebut that rebuttable presumption. But addressing the who is aggrieved, the standing question, and we would submit that these legislators have a quintessential standing to make this claim in courts. My clients, are not taking issue in this court with the substance of the legislation. No one is saying, "Hey, we're affected by the toxic tort issue at this point." What my clients are saying is that there's a constitutional provision that guarantees certain things, particularly to them as members of the legislature, and it is an injury that is distinct from the general public, and so in order to bring a claim on a 3 readings basis, we believe that we absolutely and logically would have standing to do so. We would note that standing is a concept that is applied on a case-by-case basis, and so we think that we are particularly in a position to have standing to bring these claims to you here. So thank you.
Thank you, counsel, for your arguments. We'll take the matter under advisement and stand in recess. Thank you.
Thank you.